when you refer to the fourth vertical column of the first schedule of the Criminal Procedure Code, as I mentioned you in the last part. Now this is the eighth part as far as my series of lecture is concerned, with which we are dealing at present. You come to know whether the offense is cognizable or non-cognizable. Now generally, as a student of law, whenever you come across a particular term, and if you want to know the meaning of that particular term, naturally you refer to what? You refer to section number 2, which is what is known as a defining section. So this is the time, if you refer to section 2 small c, you come to know what is cognizable offense, and when you refer to section 2 small l, you come to know what is non-cognizable offense. But if you read the definition with the book that you are having with you at present, you will find out this has got reference to what? This has got reference to first schedule, and it revolves around what? Both the section. It says, if the nature of the offense is cognizable with which a person is accused, police officer has got right to arrest a person without warrant. Whereas if the offense is non-cognizable, police officer has got no authority to arrest a person without warrant, as you refer to subject respectively subclause C and subclause L of the section 2 of the Criminal Procedure Code. So this doesn't, I mean, this has got reference to what? This has got reference to the first schedule of the Criminal Procedure Code. So though it has tried to define, you don't have a clarity as to which is the offense, in which case police officer has got right to arrest a person with warrant, or when he has got no authority to arrest a person without warrant, for which you will have to what you will have to do, you will have to refer to fourth vertical column. So I personally feel that there is no definition of cognizable and non-cognizable offenses, but there is only classification of the offenses under two different heads. Some offenses are shown as cognizable offenses and some offenses are shown as non-cognizable offenses. So in order to know whether the offense is cognizable or non-cognizable, I mean, this is the only place, namely this fourth vertical column of the first schedule of the Criminal Procedure Code is required to be referred to in order to know whether the offense is cognizable and non-cognizable. And why you should know what is the nature of the offense? For the simple reason, as a student learning criminal law, you must know basic principle of the criminal law, that anybody can set criminal law into motion. But how one can set criminal law into motion entirely depends upon the nature of the offense. If it is a cognizable offense, anybody can set criminal law into motion by following the procedure which is laid down as far as subclause 1 of section 154 of the Criminal Procedure Code is concerned, which deals with FIR, namely First Information Report. Right from section 154 up to 176 of the Indian Criminal Procedure Code, with which we shall be dealing to understand investigation and the steps that are required to be taken for the purpose of carrying out investigation, which is a collection of evidence that we will learn, no doubt about it. But if the offense now is non-cognizable, then you go to the police station, you meet the officer in charge of a police station and try to set law into motion. The officer in charge of the police station is bound to tell you, as the nature of the offense is non-cognizable, he has neither right to arrest nor to start with the investigation, and then he will refer you to go to the court of magistrate in order to set law into motion by lodging a complaint. So if it is non-cognizable offense, one has to follow the procedure which is laid down for the purpose of setting criminal law into motion, which is laid down as far as subclause 1 of section 155 of the Criminal Procedure Code is concerned. And what is this procedure? You have to go to the magistrate and you have to lodge a complaint. What is complaint? The meaning of the term complaint as it is understood in common parlance is entirely different as far as Criminal Procedure Code is concerned, because that is defined by section 2D of the Criminal Procedure Code, which says complaint is an allegation which is made orally or in writing to the court of magistrate with the view to find out whether some person, known or unknown, has committed an offence. So this is complaint. So complaint is never to the police station, complaint is always to the court of magistrate. And then, if the nature of the offence is cognizable, as per subclause 1 of section 156, police officer can start with the investigation without any order from the court of law. Whereas, if the nature of the offence is non-cognizable, police officer can start with the investigation only when a direction or order is given by the court of law as per subclause 2 of section 155 of the Criminal Procedure Code, otherwise not. At times, it becomes very interesting to know the distinction between cognizable and non-cognizable offences. By this time, we have learned that cognizable offences are those offences in which case police officer has got right to arrest a person when he is accused of a cognizable offence without warrant. Whereas, if a person is accused of an offence of which nature is non-cognizable, as per 4th vertical column of the first schedule of the Criminal Procedure Code, he has got no right to arrest a person without warrant. No, unless authority, order or direction is given by the court of law, otherwise not. It is because of right to arrest and to start with the investigation, you can come to one conclusion to know the distinction between cognizable and non-cognizable offences, that cognizable offences are serious offences as compared to non-cognizable offences. Now when I say serious, each offence is serious. Offence is an act which is done against the society at large, and it is responsibility of the state to maintain law, peace and order in the society, and hence these are the power. If some offence has taken place, the powers are with the police department. Powers are delegated to the police department for the purpose of carrying out investigation and for the purpose of booking the offender or person who has committed an offence accordingly. So now, when I say cognizable offences are serious offences as compared to non-cognizable offence, how to determine seriousness of an offence? And in order to determine the seriousness of an offence and further points of distinction as far as cognizable offences and non-cognizable offences are concerned, we will refer these provisions during the next part of my lecture.